Hello, my name is Azmi Sharom. I'm a law lecturer from the Faculty of Law, University of Malaya, and today's class is about human rights and the environment. In this class, we shall be exploring human rights and the environment. The relationship between the environment and human rights is a close one. If the environment is polluted or poorly cared for, then many rights may be affected. For example, the right to health, the right to food, water, and the right to employment. To protect the environment, there is also a dependence on human rights. For example, we can't defend the environment if we do not have the right of expression. And it is hard to mount a proper challenge against poor decision-making if there is no right to information. And if there's no democratic practices, we can't peacefully change a government who has a poor environmental record. The environment is even more important for some communities whose culture and livelihood are closely connected to the land. This is especially true with rural communities and indigenous communities. In this class, we shall explore a little bit of the history of the modern environmental movement and how environmental concerns became part of the human rights narrative. We shall have a close look at the type of human rights violations caused by the destruction of the environment. We will learn just what a clean environment means. And we will explore in detail what is meant when we say a right to a clean environment. What is this right? What does it imply? Finally, we shall study two specific issues on human rights and the environment, namely indigenous peoples and climate change. As nations become more industrialized and populations grow, concerns for the environment also become an issue. It is no surprise that environmental laws, as we understand it, started when economic development started to destroy the natural world. In America, for example, the idea for the establishment of protected national parks came about at the end of the 19th and early 20th century because areas of natural beauty were being destroyed by overexploitation. However, on the international stage, international environmental laws up until the 1970s were more about the conservation of nature for the purpose of exploitation. The Whaling Convention, for example, started life not as a protective law, but as an industrial law. The killing of whales had to be controlled, not to save the whale, but to make sure that there were whales to kill in the future. In the 1960s, things started to change. There was growing public awareness about the environment and how important it was to preserve it. Popular books like The Silent Spring spoke about the dangers of pesticides to the environment. And the Save the Whale campaign came about when people realized that these magnificent creatures were going to disappear because of hunting and that the method of killing them was pretty cruel. Environmental disasters also contributed to this awareness. In Japan, there was the Minamata Bay disaster. Now, in this case, a factory was polluting a bay, and as a result, there was a very high level of mercury in the waters. And once it's in the water, it's in the marine life. So the fishing community of this area, which ate a lot of fish, suffered tremendously with terrible illnesses, both physical and mental, as well as severe birth defects as a result of mercury poisoning.
The class so far has looked at why people became concerned about the environment, particularly from the famous case like Minamata, where many children were born with birth defects because of mercury poisoning, to the anti-whaling movement which grew in the 1970s. Around the world, more and more countries introduced environmental laws, like Clean Air Acts and anti-littering laws. The environment was an important issue in Southeast Asia, with indigenous and rural groups expressing concern about deforestation and loss of natural habitats. And people in the cities were concerned about the health impacts of pollution. Around the world, people wanted the environment protected and pollution limited. One change was the development of laws protecting the environment, which we will now discuss.
So international law started to take notice, and it really started to develop in earnest in the 1970s. In 1972, the first UN conference on the environment was held in Stockholm, in Sweden. A result of this was the Stockholm Declaration 1972, which laid down principles of international environmental law which is in use until today. The conference and the declaration also raised the profile of environmental law and its importance. Many new treaties were made, governments passed environmental legislations, and environmental agencies were created. But where does human rights come in? In the Stockholm Declaration, for the first time in international law, there was the introduction of the idea of a link between the environment and human rights. In Principle 1, it stated, "Man has the fundamental right to freedom, equality, and adequate conditions of life in an environment that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for present and future generations." You must excuse the gender non-sensitive use of the word man. This was 1972. But anyway, it was a revolutionary idea. It states that people have a right to live in a clean environment, but it also states that there is a responsibility to protect the environment, not just for the present, but also for the future. This implies that the people of the future, not yet born, also have a right to a clean environment. This idea of a right to a clean environment, it didn't go down very well at the time because it was deemed to be too vague. After all, what do we mean by a clean environment? Today, we can say that there are several elements of a right to a clean environment. First, we can look at the freedom from pollution. Pollution in the air that we breathe, in the water that we drink. We shouldn't have to drink dirty water. We shouldn't have to breathe dirty air. Then there's a right to a healthy environment. That means to say the environment must be clean so that we don't get sick just by being in it. We have the right to access to the natural environment. This could take the form of green spaces in urban areas or in areas outside the cities, protected forests, protected beaches. And finally, the right to sustainable development. What does this mean? Sustainable development means when we develop, it must be done in such a way so as to not to cause irreversible damage to the environment, not just for those of us living now, but also for future generations.
It is widely accepted that a clean environment is a human right, but exactly what is the right is still open to some debate. A clean environment can be defined many ways, such as clean air and water, or a lack of pollution. There are debates if it includes protecting wildlife or recycling waste. Another area where there is debate is the balance between the right to a clean environment and development. For example, is it better to build a road which ensures people can access hospitals or schools, even if the road destroys some of the environment and creates pollution from the vehicles which use it? While obviously it is ideal to have both a road and a clean environment, this is not always possible. The right to a clean environment does have some clear standards. A clean environment must include clean drinking water, clean air, and food. It means pollution from industry should not make people sick. Natural resources should be managed so farmers could produce food, or people can eat the fish from the oceans. Most of these elements are closely linked to the right to health, though they also relate to the right to development. A final question in the right to a clean environment is, who are the duty bearers of this right? Obviously, the state is the main duty bearer, but when it comes to pollution, it is often private companies who pollute, or individuals who litter and throw out garbage. In order to ensure a clean environment, there needs to be strong horizontal protection. That is, protecting people from violations by third parties, and this is done by having strong laws on pollution, disposal of garbage, keeping water clean, and so on. Unfortunately, in Southeast Asia, few governments have strong laws, and those that may have laws are weak on protecting them. Let's hear from an expert about these pollution problems in Southeast Asia.
This mostly relates to the rapid development in the region, which not only compromise the environment, but we're also looking at the human well-being and an increase in the socio-economic divide. If you're looking at the specifics, then we're talking about the increase in frequency and intensity in natural and anthropogenic disasters, and our ability to deal with it, especially when we're looking at forest fires and the resultant transboundary haze. Besides that, we have worsening pollution and congestion in urban centers due to centralization. We also have an increase in deforestation, land degradation, and habitat fragmentation. We also, unfortunately, have ineffective laws, legislation, enforcement, penalties, punishment, human resources, and of course corruption in high places. However, underlying all this will be rather the weak institutional arrangements for effective promotion of sustainable development and environmental protection.
Where can we find this right to a clean environment? To answer that question, let us see what an environmental right is. An environmental right can be divided into two separate types of rights: a substantive right and a procedural right. Both are important and both are interrelated. A substantive right is the legal recognition that a person has the right to live in a clean environment. A procedural right is the right to have access to decision-making and conflict resolution that a person might need in order to enforce their substantive right. So, for example, if my country gives me the right to a clean environment, this would be meaningless if I cannot go to court if I feel that my right has been violated. Where do we find these rights? Substantive rights. We can find these rights in the Stockholm Declaration, but we've spoke about that. The ASEAN Human Rights Declaration also talks about it. It says every person has a right to an adequate standard of living, including the right to a safe, clean, and sustainable environment. However, the Stockholm Declaration, the ASEAN Declaration, these are soft laws. That's to say they're influential, but they're not binding. So what about treaty laws, hard laws? Are there any? The International Covenant on Economic, Social and Cultural Rights, it alludes to the environment in Article 12, where it says that the state parties recognizes the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. The steps to be taken to full realization of these rights shall include those necessary for the improvement of all aspects of environmental and industrial hygiene. It doesn't really talk about a right to a clean environment, does it? It's very vague, it's not direct. Frankly, there are no international laws which very specifically spell out that there is a human right to a clean environment. However, at the national level, there's lots, and this is done via constitutional law. So, for example, if you look at India, their constitutional right to life has been interpreted by the courts to include a clean environment. So a right to life also means a right to live in a clean environment. Many constitutions, however, specifically put in the right to a clean environment into the body of the constitution. So, for example, in the Philippines, they have a specific provision regarding a right to a clean environment. In other words, a substantive right to a clean environment, it exists.
Let's examine the sources of some substantive rights to the environment. A substantive right is the existence in law of the right, whether that is at the international, regional, or domestic level. Looking firstly in international law, there are what is known as soft laws, which are international documents that are not legally binding. For example, the 1972 Stockholm Declaration on the Human Environment, or the 1992 Rio Declaration on Environment and Development. They are influential in establishing principles and ideas, but they cannot force a state to act. International treaties, including the right to a clean environment, are the International Covenant on Economic, Social, and Cultural Rights, which have already been mentioned. The ICESCR says that states should take steps to improve all aspects of environmental and industrial hygiene. At the regional level, the 1981 African Charter on Human and People's Rights was more specific when it stated, "All people shall have the right to a general satisfactory environment favorable to their development." In Southeast Asia, the ASEAN Human Rights Declaration states, "Every person has the right to an adequate standard of living, including the right to a safe, clean, and sustainable environment. Although the ASEAN Declaration clearly mentions the right to a clean environment, it is not legally binding. At the national level, the human right to a clean environment has been recognized in many countries. The Philippines Constitution notes, "The state shall protect and advance the right of the people to a balanced and healthful ecology in accordance with the rhythm and harmony of nature." Court decisions in Malaysia have also recognized the right to a clean environment. However, having a law is not enough. To ensure people's rights to a clean environment, many other actions are needed, and we will now look at what these are.
What about procedural rights? The best place to start with this is Principle 10 of the Rio Declaration. Now, Principle 10 says that environmental issues are best dealt with if there is proper public participation. And in order to achieve this, we need the freedom of information, meaningful participation in decision-making, and access to dispute settlement. Let's look at these things one at a time. The freedom of information. You need this in order to create a good, strong argument. If there's an environmental problem and you want to deal with it, you can't if you don't have the information, which is why it's important to have freedom of information laws. Indonesia, for example, has freedom of information laws. But in other countries, like in Malaysia and Singapore, you have the anti-freedom of information laws in the form of Official Secrets Act. So it depends which country you're in, but it's an important factor. The second one is about participation. And by participation, we mean meaningful participation. How can the public participate in environmental decision making? There are two ways generally. The first one is the environmental impact assessment, and the second is through town and country planning processes. Let's look at the EIA first. The EIA is basically a method with which environmental concerns are taken into consideration before development occurs. And in this process, ideally, you should get feedback from the people, particularly those who are living in the area. Now, the method with which you get this feedback is very important. It has to be meaningful. You have to get as many people as possible to give their opinions. And it's no good if you only ask a small group of people who already are in favor of the development project. The other method is through town and country planning processes. This is where if a development project is happening next door to you, you have a right to speak about it. Again, it has to be meaningful. Now, what do I mean when I say meaningful? Let me tell you a story. In Malaysia, there are town and country planning laws. And one person I know went to the relevant agency, and he gave his views regarding a project which was happening next door to him. The officer in charge sat there with him and listened to him for a good hour. The man did not take notes, and he did not record the conversation. And in the end, the law says that what needed to be done had been done. So in other words, all you had was a right to speak your mind. But it means nothing because it was not taken into consideration. So if you have a law which allows for public participation, you must also make sure that whatever views were given was taken into consideration. The final element to procedural rights is the access to dispute settlements. What does this mean? Basically, people must have access to courts. The trouble with environmental cases is that sometimes environmental damage does not necessarily mean that a human being is damaged. And courts, more often than not, need to have someone who's directly affected before they can appear before the judge. So we need to have a broad definition as to who can bring a case to court. Basically, the term here is public interest litigation. This means I'm bringing a case to court not because I was hurt, but because it is in the public interest to do so. For proper environmental procedural rights, there must be public interest litigation, and this must be allowed for by the courts.
A procedural right to clean environment means that people should be informed and able to participate in decisions about the environment and challenge any activities which violates their right to a clean environment. There are many elements to this which the class has already covered. These include the right to environmental information. Governments should be spreading information about keeping the environment clean and impacts on the environment. To support this, people should be able to access this through freedom of information laws. However, in Southeast Asia, only Indonesia, the Philippines, and Thailand have these laws, and they are weak or underused. Indonesia has a 2008 Freedom of Information Law, and Thailand's law first appeared in 1997. In countries like Singapore, no such law exists. The laws are meant to stop governments seeing themselves as above society and able to make decisions without public input. Without information, it is very difficult for people to act against projects, which may harm the environment. Another key area is participation. Among the ways to participate in environmental decision-making are through environmental planning regulations and environmental impact assessments, or EIAs, both of which should include public participation. An EIA is normally undertaken by an independent group who can access and report on what the environmental impacts are going to be, and in most countries, they are legally required before any major development occurs. These procedures allow the public to voice concerns about developments and ask for them to be modified or changed if they will violate the rights to a clean environment. Lastly, there is a procedural right to access and remedy cases of potential environmental harm. This can be the right of locus standi, or the right to appear in court. However, it does not have to be a court, as it could be another form of mediation. This right is about the access to justice, to ensure changes to the environment are done by the rule of law. Let's now turn to an expert on why people's participation in decisions about the environment are so important.
In 2 words, I would say, why not? If it affects your life, then you should be. So when we talk about participation, not only we're talking about an empowerment in terms of decision making that affects their lives, but frequently participation leads to a better outcome, a better product. Or like we were talking about, we're going for economic development, right? So we can eventually come up with a better project that addresses the mitigation of those projects if the local stakeholders have an opportunity to voice their concern or even to relate their traditional ecological knowledge or their local ecological knowledge, which science may not have information of. So yes, from the social side, everyone who is affected should be involved, should be given a chance to participate, voice their opinion, be aware, and secondly, their contribution to the information base could help develop better in terms of addressing the impacts of the projects. But I would like to say something more. When we say participation here, I would like to emphasize informed participation rather than participation. By informed participation, I mean that often the stakeholder communities or the stakeholders are not fully informed. So frequently they contribute to the decision making without having the full knowledge of the issues on hand. And later on, it leads to other problems, as we frequently see.
The threat that the environmental activists face, apart from intimidation, killing in the past, now most of them face what we call the judicial harassment. The investor, business investor, like mining owners, or the factories owners, they use the litigation to harass the activists by bringing the case to the court. They allege or accuse them of defamation, offense and demand, in some cases, the compensation when the activists disseminate the information about the environment violation. And there are so many lawsuits that they face now. What we call that is the SLAP, right? That try to prevent the participation of the environmental activists from monitoring the violation of the environmental rights of the communities. Yeah. We don't have the anti-SLAP law as those in North American countries or in some European countries. And in Thailand, the private sectors or individual can bring the case to the court directly without bringing the case or filing the complaint to the police. So that in many cases, the case tried by the court, initiated by the companies who own mining or own factories that make the pollution to the communities.
So to sum up, procedural rights mean freedom of information, it means meaningful participation in decision making, and it means access to the courts. We mentioned earlier about indigenous peoples. Now, indigenous peoples, their lives, their culture, their religion, it depends very much on the land that they live on. There's a very intimate relationship between them and their land. And in this way, their issue is also an environmental issue. And the key principle here can be found in the United Nations Declaration on the Rights of Indigenous People. What I want to look at is just one particular principle, which is known as FPIC, Free, Prior, Informed Consent. What this means is that if you're going to do anything to indigenous lands, you must have free, prior, informed consent. What does this mean exactly? Free means that whatever consent they're given cannot be forced, cannot be coerced, cannot be bribed. It has to be free. Prior means their consent must be given before the development plans have been agreed. There's no point agreeing to do something to their land and then after that asking permission. It makes no sense. Informed means they must be given all the facts. And not just that, but it must be provided in a manner with which they can understand. And finally, consent. What does consent mean? It's been generally accepted that consent means the entire community must be happy before you can actually encroach into their lands. So that's a very, very important principle with regards to indigenous peoples. The next issue is climate change. Now, despite what some people might say, climate change is real. It's happening, and it's happening because of human activities. You might wonder, how does this affect human rights? In a lot of ways. Climate change basically means the Earth is getting warmer. And when it gets warmer, one of the effects of this is rising sea levels. When the sea levels rise, low-lying countries will be severely affected. And when this happens, people's lives will be affected, and their livelihoods will be affected. Another effect of climate change is the rising temperatures. And for countries which are hot, particularly countries which are desert, this could lead to famine because of crop failure. Both these things, rising sea levels and rising temperature, could lead to another thing, which is the movement of people from their lands, which they can't live in anymore, to other people's countries. So you're going to have a problem with refugees. For the first time in the history of our planet, we might have environmental refugees. The last point with regards to climate change is that with the change in temperature, some countries are going to get warmer. And these countries, which never used to experience things like vector-borne diseases, that is to say diseases carried by insects like mosquitoes, are suddenly going to face new problems. Problems which used to be Southeast Asian, like dengue and malaria, could be suffered in France and England because they're getting warmer and the mosquitoes survive. So as you can see, climate change affects the right to life, it affects your right to health, and it affects your right to livelihood. It has a lot of effects, and it has to be considered. In conclusion, Environmental rights is relatively new compared to the freedom of expression and the freedom of religion. But nonetheless, it's very important, and it's growing in importance because, as we can see, the environment is getting worse, and with it, so is our rights.